Mr. Levitt, anything from you before we get started?
No, Your Honor.
Okay. All right. Go ahead, sir.
Thank you. I'll go through the issues as I see them. I'm sure if I miss any issues, Counsel McLean will bring those up. The first that I will address is the start date of the new order. The state filed their motion to adjust on July 11th, serving the parties shortly thereafter by mail. In August, both parties hired counsel and notices of appearances were filed. And towards the end of August, discovery requests were sent out. Because of those pending discovery requests, the parties agreed that the state could withdraw from the motion because both parties were represented, and it would allow time to exchange discovery. So from mother's perspective or petitioner's perspective, we are asking that support begin.
A quiet courtroom opening quickly shifts into structured legal debate as counsel begins outlining disputed financial issues. The central question emerges early. When should the revised child support order actually take effect? The state's filing timeline is dissected, highlighting procedural delays, discovery exchanges, and representation changes. A tense foundation is laid as both sides prepare to challenge how far back support adjustments should apply.
The new support begin August of 2025. And the reasoning is what I just explained, because the state's motion was filed in July, parties were on notice in July. Before that petitioner had reached out to the state or to DCS to begin collection and to begin enforcement. The next issue that I will address is just kind of the traditional issues of where you set the parties' incomes. As to petitioner's income, she is a W-2 employee of her husband's business, Pacific Pole Inspection LLC. Her income is relatively straightforward. It's the same month to month, and I don't believe there are any disagreements as to how her income was calculated pursuant to her W-2 employee income. Mm-hmm. The disagreements and the trickier issues come into play with respondents' request to include Pacific Pole Inspection as a source of income for petitioner herself. And I haven't received any...
Attention turns to income determination, where the petitioner's earnings appear straightforward as a W-2 employee. But the discussion escalates when opposing counsel raises the issue of additional income linked to a family business. The courtroom atmosphere tightens as financial transparency and classification of income sources becomes central to the dispute, setting up a deeper conflict over what should legally count toward child support.
Notice that the claim of that being a community asset was rescinded, so I'm going to go ahead and go into it. But the parties were married in 2028 or 2018, is that right? Let's see. Yeah, 2018. Mr. Pionio filed the certificate of formation for that business in May of 2013, 5 years before marriage. Petitioner's position is that the business is her husband's separate property, and pursuant to the child support statute, income from a spouse, including business income from a new spouse, is to be disclosed to the court, which it has been, but is not to be included for purposes of child support. Because of that, the business income itself for the business Pacific Pole Inspection LLC should not be included for petitioner's income. I understand there may be some argument as to the parties receiving a benefit, a personal benefit to the or to the marital community from the business. Respectfully, that is outside of the scope of this court's purview for purposes of child support.
The debate intensifies around whether a business owned by the petitioner's spouse should factor into child support calculations. Counsel argues it predates the marriage and should remain separate property, legally excluded from income attribution. However, opposing arguments suggest indirect financial benefits may still influence household income. The court is left navigating a complex intersection of family law and business ownership classification.
It would still be the source of the income is still from that business itself. And so it would still be considered the separate income of petitioner's current spouse. As to the rental properties, I'm aware of some disagreement as to how the net income was calculated. So we went through and provided new calculations at the end of last month. Those were attempted to be filed under seal. The clerks rejected that. So on the 27th, they were filed as just a submission document. Instead of a gross or a 10% estimate for all transition costs and repair costs, we went through and delineated exactly what petitioner and her spouse paid throughout the years for which they filed taxes, 2022, 23, and 24, showing what those costs actually were and providing an average of those, then adding that back in. There were no other disagreements of which I'm aware as to how to calculate the income from the rental properties. There was a disagreement about whether to include one of the properties. I believe it was the Juanita property.
The focus shifts to rental properties and how income from them is calculated. Adjustments to expenses, repairs, and tax-related deductions become critical points of disagreement. Counsel emphasizes revised financial submissions meant to replace estimates with actual historical costs. The courtroom closely examines whether the updated calculations fairly reflect true net rental income or distort financial reality.
JUANITA, that property was sold and it was excluded from the income calculations both before and after receiving respondents' materials. So we're asking that Your Honor set the petitioner's income as her W-2 employment income gross of $5,000, taxes, FICA deductions per her pay stubs, the other mandatory state deductions also per her pay stubs, results in a net income of $3,500. And then on top of that would be her 50% share of the gross rental monthly income and the normal business expenses, which brings her income up somewhat. All of that was filed as a sealed or non-sealed submission on the 27th. As to respondents' income, I didn't see necessarily an analysis or how the numbers were arrived at from his pay stub from respondents' materials. We went through and provided the income analysis showing the average per pay period, gross income, and the average monthly. So we took the year-to-date income, divided it by the number of that pay period was in the year. I believe the most recent pay statement provided was his sixth. I'm sorry, that is
Final income figures for the petitioner are presented with structured calculations combining employment earnings and rental income shares. The argument is framed as precise and documented, relying on financial submissions filed under seal. Meanwhile, respondent income analysis is introduced using averaged payroll data, signaling that both sides are now locked in competing mathematical interpretations of financial capacity.
That is his wife's income. So it was the 22nd out of 24 pay periods in the year. Year-to-date totals divided by 22 gives you the average per pay period amount. Multiplied by 24 is the yearly amount. Divided by 12 is the monthly amount. And that is on page 6 of our financial source document submission filed on the 27th. Respondent should also receive a credit for how much he's actually paying for the children's health, vision, and dental insurance. We provided our calculation for those expenses, which was also provided from counsel herself. Those are attached to the reply declaration filed on February 23rd. As to the other issues of which I'm aware, we have respondents' defenses. Well, I'll get to the equitable defenses next. But first, I want to address the request for attorney fees based on intransigence. It seems like most of these intransigence claims were coming from assumptions about things that Mr. Rice believed Ms. Peonia was doing and not necessarily things that she actually did. One of those was his claim that she lied to support enforcement or didn't disclose those direct payments. Attached to her reply declaration as Exhibit E are all of the emails she exchanged with support enforcement.
The courtroom shifts into respondent income evaluation, with counsel explaining a step-by-step payroll averaging method. The calculation process is laid out in detail, aiming to standardize fluctuating income into monthly figures. Additional credits for health, dental, and vision insurance are introduced, reinforcing the argument that respondents' actual financial burden should be adjusted downward based on documented contributions.
Page 12 of that document, which I believe is the second page of Exhibit E, includes the email where Ms. Peonia says the past due amount is incorrect. Jesse has paid me the $600 a month until August 2022. And I believe there may have been some evidence provided that he actually paid through September. So the difference would only be 1 month. But anyways, he assumed that because of the way DCS was calculating his arrearage, it was significantly more than what he anticipated. He assumed that Ms. Peonia was not providing that information to DCS. She did, in fact. And DCS came up with a different calculation. His other basis for requesting attorney fees is that she filed a motion for adjustment versus a petition to modify child support, and the relief that she was requesting exceeded the scope of what is typically allowed in a motion to adjust child support. The case law that I provided, I believe the case was directly on point, stated that there really is no detriment to the non-moving party facing a motion to adjust rather than a petition for modification. In this case, I will also note that respondents' discovery requests were provided and responses to those discovery requests were provided well before he filed his petition to modify. So he did face really no detriment based on that procedural choice. So essentially that is a harmless error. He should not be entitled to attorney fees because she chose to file a motion to modify rather than a motion to adjust rather.
Allegations of bad faith surface as attorney fees tied to intransigence are debated. Counsel argues that many claims are based on assumptions rather than verified misconduct. Emails and support enforcement communications are cited to challenge accusations of non-disclosure. The courtroom tension rises as credibility and intent become central, shifting the case from numbers to behavior and alleged procedural abuse.
Petition to modify. Finally, that was also the motion that the state brought before either party had retained counsel. Therefore, she filed the same motion. Then we get to the request for relief from child support arrears. There are actually three bases that Washington courts have found to support relief from child support arrears, and those are three equitable defenses. Laches is one, equitable estoppel is another, and I'll have to look at my old brief for it, but there are three bases. Laches and equitable estoppel can essentially be analyzed together. One of them has three elements that focus on the delay, that's laches. The other focuses on an act or inact that caused harm. Respondent's position seems to be that twofold. Essentially, we had an agreement, and I relied on that agreement in allowing her to claim the tax deductions. The evidence that he provides cannot meet that clear and convincing standard because the text message that he provides shows that there was not an agreement at the time that child support ceased being paid. He stated in that text message himself that no, he still wanted to claim the children. It was not in reliance on some agreement not to pay child support. It was not in reliance on that he allowed her to claim the children. That was done well after the fact. So there essentially is no harm, and no harm for the equitable estoppel claim.
Procedural strategy becomes the focus as the distinction between a motion to adjust and a petition to modify is examined. Counsel argues the choice caused no real disadvantage, labeling any issue as harmless error. Discovery timelines are referenced to show both parties had access to information regardless of filing method. The argument attempts to neutralize procedural objections by framing them as non-prejudicial.
As to the laches claim, there has to be damage resulting to the defendant from the delay. In this case, the delay was the delay in reinitiating state enforcement or reinitiating state collection. And the applicable quote here is that respondent cannot prove damages simply by showing he has to do now what he was legally obligated to do for years. As to the tax issue, that can be remedied with the new order quite easily, allowing respondent to claim the children once he becomes current on his child support obligation, or allowing him to claim for 1 to 2 years before going back to alternating. And let's see, with that, I believe I have addressed all of the known disputed issues. A respondent has to prove clear, cogent, and convincing evidence standard. And so it's less than reasonable doubt, but more than preponderance of the evidence. We provided evidence that there was some sort of agreement to stop collecting child support. Petitioner provided in her reply declaration her explanation. There was quite a bit of hostility towards her that was affecting the children. She couldn't think of any other way to get that hostility to decrease other than by canceling child support. Petitioner or respondent's position appears to be that they agreed in 2022 to cancel child support and nobody would receive the benefit of that, not in 2022, not in 2023, but at the earliest in 2024, at the time that the parties would file taxes for 2023. It just doesn't add up. So for that reason, we're asking that his equitable defenses against child support arrearages be denied.
The courtroom enters equitable territory as defenses like laches and estoppel are introduced. Counsel argues the respondent cannot demonstrate actual harm from delayed enforcement. Alleged agreements are questioned for lack of clarity and consistency. The legal standard of clear and convincing evidence is emphasized, raising the bar for proving any informal arrangement regarding child support cessation.
Is there anything that Your Honor feels you need more explanation or argument as to petitioner's position?
I don't think so. I think what I'll do, I'll hear from the other side and then give some rebuttal. And I do have just general questions that might be more of a group discussion, just kind of making sense of how this all played out over the years. But rather than kind of pin that on petitioner necessarily, I'll hear from respondent. Sure. And we can have a brief discussion. Thank you, Mr. Levitt.
Thank you.
All right, go ahead, Ms. McLean.
Thank you very much, Your Honor. So on behalf of Jesse Rice, the respondent in this matter, as you know, I'm usually a little more verbose. So, and to sort of dovetail into your initial suggestion there about having a question about the history, that's exactly where I'm starting at. These parties divorced back in 2017, at which time the children resided primarily with Ms. Pionio. At that time, Mr. Rice was ordered to pay $1,138.59 a month that started in July of 2017, and payments were made directly to Ms. Pionio at that time. There was written correspondence dated May 1 of 2019 from Ms. Pionio acknowledging to the Office of Support Enforcement that he was current in his support. And this is, and I guess that maybe I should ask, are you working off of my trial notebook that we sent over, or so would you want me to refer to tabs, or do you want me to refer to clerk's papers?
Tabs would be great because I have both of your binders in front of me.
Okay, so if you take a look at our tab H, Exhibit C, C as in cat, you'll see that she's written this letter dated May 1 of 2019 that says that he's current and up to date on all child support payments through April 30th of 2019. So as of that date, he's current. The parties then agreed to modify the child support order, and they entered into a joint custody parenting plan in July of 2019. The child support order that was entered on July 23rd provided for Mr. Rice paying $800 per month in child support.
Judicial skepticism becomes evident as the validity of the alleged agreement is questioned. Counsel struggles to align text messages with claims of mutual consent. The court highlights inconsistencies in timing and intent, particularly regarding tax benefits and delayed enforcement. The discussion underscores a core issue: whether informal communication can override formal child support obligations.
That commenced July of 2019, and the child support was deviated due to the joint custody. At that point, my client was not, I don't believe he was remarried, and but he didn't have at least the whole family deviation for his other two children. So the deviation at that time was based solely on the joint custody, and that took effect July of 2019. There was another child support order that was entered November 17 of 2020, and that's the existing current child support order. That child support found that my client's net income at that time was $6,471.86, and Ms. Pionio's net income was $2,893.73, and it set child support at $600 per month, effective December 1 of 2020, again with payments going directly to Ms. Pionio. So one of the issues or claims that has been floating around here is that she did not provide proof of those payments or allow claim to those payments when she asked for enforcement. And so part of these arrears are for that $600 per month that my client was paying direct. If you take a look at our sealed financial source document, and I've provided this to you at at tab L, those are all of his bank statements from May 1 of 2019 through May 30th of May 31, of 2022. And the reason we provided those was to show and verify his payments. We provided the case payment history that Ms. Pionio had produced to us. That's at pages 4 and 5 of that same exhibit. And then we produced, so you'll note that they do not, this calculation or sheet does not reflect his direct payments to her between after November 24 of 2020, through his payments in May of, not May of 22. Oh yeah, I think it would have been May of 22 because that's when they reached the agreement.
The respondent's counsel begins a detailed historical reconstruction of the case, tracing back to the original 2017 divorce order. Early child support obligations and custody arrangements are outlined to establish context. The narrative emphasizes that payments were historically made and modified through court-approved orders, framing the current dispute as part of a long procedural evolution rather than a sudden conflict.
So we had to produce all of his bank statements to provide proof of that, because that hadn't been given, even though the order provided for a direct payment to her at that time. Also in that November of 2020 order, Kate, the child Kate, was allocated to my client as a tax exemption, and to Ms. Pionio, she received, is it Courtney? Oh, Hallie, pardon me. Hallie as a tax exemption. It also ordered my client to pay health insurance for the children. And I would note that the child support order at, I believe it's paragraph 22, allocated uninsured health care expenses and reasonable daycare expenses. Those were the only additional expenses that were allocated. And my recollection, although I'd have to turn my back and pull the, actually, no, I have it. If you take a look at Exhibit G, that's the existing final order of child support. And if you take a look at paragraph 19 on the taxes, it talks, and I guess I just picked up on this when during Mr. Levitt's argument, he claimed that, well, he should only be allowed to claim the children if he's current in his child support obligations. Paragraph 17, apologies. Paragraph 17 does not require a parent to be current in their child support in order to claim the child for purposes of taxes. So that's a new claim and allegation. That existing order did not require that. Again, however, in 2020, there is no claim for back child support by Ms. Pionio. And again, she asked OSC to stop collecting the child support and provided for direct payment to her.
Bank statements and payment records are introduced as evidence of consistent direct child support payments. Counsel highlights documentation spanning multiple years to validate compliance. The focus is on proving that payments were made outside formal enforcement tracking systems. This evidentiary phase aims to establish financial responsibility continuity despite disputed accounting records.
The payments that we have provided in our tab L are also allocated in my client's declaration that's filed at tab H. The calculation at Exhibit A. This is the calculation of the child support at $600 per month through September 1 of 2022. He made consistently made payments and actually made his last payment on September 9 of 2022, again, because of their agreement. And then you see from the documentation that based on Ms. Pionio's request, she now has the Office of Support Enforcement garnishing his wages, and those garnishments started July 16 of 2025, and they continue to this day. In September 19 of 2022, the parties did agree through text that there would be no child support, and Ms. Pionio would claim both of the children as tax exemptions. And again, that's at our tab H, and it's Exhibit D. And it's notable that it is Ms. Pionio who reaches out to my client. She's the left-hand justified on September 19 of 2022. She says, hey, I'm going to try and get all of the info to my attorney today since I'm dropping all support. That's her pronouncement. She's dropping all support. I'm going to change it so I can claim both girls on taxes. Are you okay with that? He basically says, look, I've paid child support for 9 months. This is what I've been planning for this year. I want to be able to claim the one child this year that I've been doing, and then it would start the following year. And look at what their tax returns show. The tax returns show exactly that. My client claimed the one child in 2022. She claimed both children in 2023. She claimed both children in 2024. So that's her offer, his acceptance, and both of them have relied and acted upon that.
Tax exemptions and custody-linked financial arrangements take center stage. The 2020 order is dissected to clarify who claimed which child for tax purposes. Counsel emphasizes that exemptions were part of structured legal agreements, not informal understandings. This section builds the foundation for arguing that later tax filings were consistent with prior arrangements and expectations.
Let me, just so I don't lose this point.
Sure.
So when I look at this text message, I struggled with this being offer and acceptance. And so there must be something more that happened. And that was kind of what I was getting at with some of the historically. Something happened here. Did they call each other and he finally gave in and agreed to it, or what? Because the text message would show she threw it out there. He said, nah, not interested. So then what?
They had further conversations after the fact, is my understanding.
Just oral conversation. I mean, or not just, but they had oral conversations. Then no follow-up text that I'm missing.
Not that I'm aware of.
Okay.
As far as follow-up text, and even if the court record would reflect that Ms. Pionio was also shaking her head as it related to communications after the fact by phone. So my client had paid child support through that $300 payment in September of 2022. They both filed their taxes. If you take a look at her 2022 tax return that's filed under their, I think it's Exhibit 16, 2022 tax return is on page 241. Sorry, I didn't mean to cover you up. Is on page 241. You'll see that she claims Hallie. And then if you take a look at the 2023 tax return on page 177, and I'm referring to the Bates numbers that are identified below. I'm sorry, it's 176, apologies. She claims both Hallie and Kate. And then the 2024 tax return, at page 92, again, she claims both Hallie and Kate. So she's relied upon that. She's received a financial benefit for being able to claim those girls, and that is the source of their agreement. So they've both followed through with that. I would also note, first off, and I'm getting a little astray from my history here, but just because it's fresh and the court had asked about it.
A disputed 2022 text message becomes a critical turning point as counsel argues it reflects a mutual agreement to stop support payments. However, uncertainty emerges over whether true acceptance occurred beyond the message. The judge challenges the clarity of consent, questioning whether additional conversations occurred. The issue of intent versus interpretation becomes central to the dispute.
The courthouse doors have not been closed to Ms. Pionio. The Office of Support Enforcement has not been closed to Ms. Pionio. She very well could have in 2022, when he stopped making direct payments to her, asked them to do direct collection against him, garnishment against him. She also could have filed a contempt motion. She's done neither of that. And because of that, my client has relied upon their agreement in not making payment. The other thing that I would point out is I'm still a little baffled as to why we are arguing this, because when I go to Ms. Pionio's own declaration that was filed on February 23rd of 2026, and I'm not sure which clerk paper this is. I didn't mark that. I apologize. And I didn't have it identified as a number in their notebook or in any event.
Yep.
Her declaration filed February 23rd of 2026, page 2, line 24. I am not seeking a judgment against the respondent for child support arrears. So I'm not, are we arguing this or not arguing this? If you go back and look at the documentation that she files from her communications with the Office of Support Enforcement, she says, this is on exhibit, so this is exhibit E. The very first one says, the support owed now is $600 per month starting December 1 of 2020. So again, they still don't know about all of his payments that he's made and the tax or the bank statements that we've produced. She said, the caseworker, Ms. Rakestraw, I believe is how you pronounce, Anna Rakestraw, says, you'd mentioned you wanted to forgive all or some of this debt. So back in May of 2025, Ms. Pionio is telling her caseworker she's wanting to forgive all or part, and her own declaration says, I'm not seeking a judgment. So I guess the question is, doesn't that mean that she's acquiesced in the argument that she acknowledged that she forgave that $600 in return for being able to claim the children and that they've moved forward from there?
The courtroom examines tax filings from 2022 through 2024, showing consistent reliance on claimed agreements for dependency exemptions. Counsel argues the petitioner benefited financially while now disputing the arrangement. Enforcement delays and alternative legal remedies are questioned, including failure to seek contempt or formal enforcement earlier. The respondent frames the situation as reliance on a long-standing mutual understanding. As arguments conclude, the narrative culminates in competing interpretations of agreement, enforcement, and fairness in child support obligations. Like the video, subscribe to the channel, and we'll see you in the next video.
She goes on to say, and this is where counsel is suggesting that she advised OSC that he in fact paid her. This May 14th email, Ms. Pionio says, the past due amount is incorrect. Jesse paid me the $600 a month until August of 2022. So the difference should be from September 22 until current, not from December 2020. I'm not sure if I'm going to forgive that debt or not yet. This is in May of 2025. Again, acknowledging by implication that they've already agreed that there's not to be a child support order and that they both acted on that. Going back to the history in this, the parties agreed to modify the parenting plan in 2023. Again, there was no discussion about child support, no discussion about arrears. The parties continued with the no child support payments, and Ms. Pionio, in her declaration for the first time, as I indicated on page 2 of that February 23rd, says she's not seeking this judgment. But then she does say that she wants the court to deny the relief requested in the child support order. I'm assuming that's the other relief requested by my client. In regard to the next action that took place after the parenting plan was modified in 2023, and again, I would note the parenting plan provides absolutely no 191 factors, no suggestion that my client's harassing her, pestering her, or that he's been inappropriate in any way. There's no text messages that support that conclusion. This is simply an attempt to garner pity from the court to suggest that she was somehow under some undue influence after the fact. And my client adamantly denies that. The state filed a motion to adjust child support, including providing a memorandum on a stepped up basis. At that point, no discovery had been conducted, and there was no whole family deviation that had been considered, given that Mr. Rice has 2 dependent children within his household. The state's motion was withdrawn. By agreement, it was withdrawn. And if you look in the record, you'll see that there's a notice of withdrawal